Welcome to NIPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nipt.com/law to read the full decision.
People v. Ricard Licius, decided October 23, 2025. Wilson, Chief Judge. Mr. Ricard Licius contends the misdemeanor charges against him must be dismissed because the people electronically filed their statement of readiness on the due date at 5:03 p.m. instead of by 5 p.m., we disagree. Electronic submission of a statement of readiness on or before the due date, regardless of time of day, satisfies the CPL 30.30 deadline. 1. On May 3, 2022, Mr. Licius was arraigned in criminal court on a misdemeanor complaint. There is no dispute that August 1, 2022 was the date by which the people were required to announce their readiness to comply with the CPL 30.30 speedy trial deadline. On that date, at 5:03 p.m., the people submitted a Certificate of Compliance, Statement of Readiness to the court through the court's Electronic Document Delivery System, EDDS. The people also served the documents on defense counsel that day. The clerk's office was closed at the time the people filed the SOR and other documents through EDDS. The following morning, on August 2, 2022, at 9:56 a.m., the clerk's office marked the SOR as filed as of August 1, 2022, and notified the people. Mr. Licius's counsel moved to dismiss the accusatory instrument pursuant to CPL 30.30 does not permit the prosecution to state, it is ready for trial after the court's close of business on the final day of the statutory speedy trial period, and also that the SOR was not filed until the clerk's office reviewed and accepted it on August 2, 2022, after the speedy trial period had elapsed. Criminal court granted Mr. Licius's motion to dismiss, holding that the people's 5:03 p.m. filing was invalid because the people must be beginning a trial when they announce readiness. The appellate term reversed, holding that the people's readiness and the court's ability to commence a trial are separate issues, and that since the implementation of EDDS, documents can now be deemed filed by the clerk. A judge of this court granted Mr. Licius leave to appeal. We affirm. 2. This case presents two legal issues for our review. A. Does electronically submitting an SOR after the court has closed on the last day of the applicable satisfy the requirement that the people be ready for trial within that period, CPL 30.301, and must an SOR also be reviewed and deemed filed by the court within that period? First, electronic submission of an SOR before midnight on the due date satisfies CPL 30.30. CPL 30.301 requires that the people validly declare their readiness for trial within the applicable speedy trial period, either on the record in communication to the defendant and court to be placed on the record, see People v. Kenzia. In People v. Kenzia, we held that, to satisfy the statutory speedy trial obligations, the people must, 1. Timely, make a communication of readiness which appears on the trial court's record, and 2. At the time of that representation, be in fact ready to proceed. Electronic delivery before midnight on the calendar day of the statutory deadline satisfies CPL 30.30 because there is no requirement in CPL 30.30 or our case law that the people's readiness be communicated to the court and defense counsel by any particular time of day. Indeed, General Construction Law Section 19, which is applicable to every statute unless its general object or other provisions of law indicate that a different meaning or application was intended, specifies that a calendar day includes the time from midnight to midnight. This is incompatible with Mr. Licius's position that the day ends at 5 p.m. Nothing in CPL 30.30 evidences that a contrary interpretation was intended. The people, not the court, are subject to the CPL 30.30 deadline. Contrary to Mr. Licius and the criminal court's view, the people's trial readiness does not depend on whether the court is closed, about to close, or otherwise unavailable to commence trial. The statutory speedy trial framework requires the people to be ready to commence trial by a date certain, without regard to whether the court is able to commence trial. It is well settled that time elapsing because of court unavailability is not charged to the people when determining trial readiness, see People v. England. CPL 30.30 was enacted for the narrow purpose of ensuring prompt prosecutorial readiness for trial, and its provisions must be interpreted accordingly, People v. Sinestage. Mr. Licius further contends that even if the people had until midnight on August 1 to submit their SOR, because the people used the EDS to submit it, and because the clerk's office did not review and accept it until the morning of August 2, it is nevertheless untimely. He relies on 22 NYC or 202.5C, CRO, which states that documents sent through EDDS shall not be deemed filed until the clerk of such court or his or her designee shall have reviewed the documents and determined that all other filing requirements have been satisfied. Mr. Licius argues this language requires the court to declare the people's SOR deemed filed within the CPL 30.30 90-day deadline. We reject his interpretation because CPL 30.30 regulates only the people's SOR submission, not the clerk's review of the SOR submission. The validity of an SO does not turn on the speed with which the clerk's office reviews and accepts filings. The purpose of the SOR is to require the people to state or otherwise provide notice that the people are ready for trial, CPL 30.305. In submitting the SOR through EDDS at 5:03 p.m. on August 1, 2022, that purpose was fully served. Both the court and Mr. Licius were put on notice of the people's readiness. SOR deemed filed within the CPL 30.30 90-day deadline. We reject his interpretation because CPL 30.30 regulates only the people's SOR submission, not the clerk's review of the SOR submission. The validity of an SOR does not turn on the speed with which the clerk's office reviews and accepts filings. The purpose of the SOR is to require the people to state or otherwise provide notice that the people are ready for trial, CPL 30.305. In submitting the SOR through EDS at 5:03 p.m. on August 1, 2022, that purpose was fully served. Both the court and Mr. Licius were put on notice of the people's readiness. 3. In sum, the people's use of the EDDS to deliver their SOR at 5:03 p.m. on the last day of the speedy trial period met the requirements of CPL 30.30. Accordingly, the order of the appellate term should be affirmed. Order affirmed. Opinion by Chief Judge Wilson. Judges Rivera, Garcia, Singas, Canataro, Troutman, and Halligan concur. Decided October 23, 2025.
Welcome to NYPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypt.com/law to read the full decision.